What are the 3 mistakes that a Social Security judge can make in denying your benefits? As a Social Security disability attorney, one of the worst calls I ever have to make is to that of one of my clients to say, hey, the judge ruled against you. And now we've got to figure out what we're going to do. Are we going to give up? Are we going to start all over, giving up the back benefits? Are we going to file an appeal with the Appeals Council? What I'm looking for is what we call legal error. And one of the reasons that a judge will deny a claim is based on credibility decisions. They will look at your medical records, they'll listen to your testimony, they'll look at the forms that you've filled out or forms that others have filled out on your behalf. And they're looking for consistency about the nature of your symptoms, the intensity, the duration, the frequency. I also find that they cherry pick medical records and testimony looking for discrepancies. Now, it really depends on where you live, because based on the circuit in which you live, the courts may require that an administrative law judge provide detailed reasoning why they've concluded that you're not credible. Another mistake I find they make is in medical determinations. Now, while the opinion of your physician should be given greater weight by the Social Security judge over the opinions of the state doctors who've just reviewed your medical records, that's often not the case. And I think it can be a great reason for challenging the denial based on how the judge has written that decision. The third mistake is vocational determinations. Now, the judge has to decide at step 4 whether or not you can go back to your past relevant work, and at step 5 whether you can do other work in the mythical, hypothetical, not real-world national economy. You'll recall at the hearing there was another witness, a vocational evaluator, and the judge asked them hypothetical questions about your ability to work. Now, the judge formulates that hypothetical based on the medical records in your file, hopefully residual functional capacity forms. And they'll certainly will take into consideration the opinions of the Social Security consulting physicians. Often I find that the judge will make mistakes in formulating the hypothetical, which result in the VE opining that you can go back to your past work or do other work in the mythical, not real-world national economy. That can be a reason for filing an appeal to the Appeals Council. Now, I know, again, that you've waited forever, and the idea of taking an appeal to the Appeals Council can be unpalatable, if you will, because it's going to take at least another year. Remember, your options are to give up, file a new application giving up the back benefits, or filing an appeal with an Appeals Council. Again, you should be represented by an attorney, and that attorney should be looking at the decision and giving you advice as to whether or not you should file an appeal to the Appeals Council or what your options are. If we've represented you in the case, certainly we'll be giving you our opinion as to what your options are. This is a complex area of the law, and some difficult decisions need to be made at that point in your case. If you have any questions about the Social Security disability claims process, an unfavorable decision, what your options are, give us a call. We can't guarantee to you that we'll take your case, because generally, as a rule, I don't like to take the mistakes of other lawyers. But we're certainly available to give you our opinion as to whether or not an appeal is appropriate. We call it a second opinion. We're certainly not going to interfere with your relationship with your attorney, but certainly you're entitled to get a second opinion. 727-894-3188.